Good afternoon, everyone. This is Mailda Frawi, and I would like to welcome you all to the ICC Qatar's webinar, Emerging Trends in International Disputes, which we have organized it in collaboration with Crowell Moring. Before we begin, I would like to call your attention to the Q&A button, which is down the screen, which we encourage you to use as we have allotted some time towards the end of the webinar for our panelists to answer your questions you may have. Please do not use the chat button, as our panelists will not be able to review your comments while they are speaking. And thank you very much for your attention, and let us welcome Mr. Tarek Saad, the General Counsel at Crowell Moring, Qatar.
Hello, thank you, Mai, for that. It's been a real pleasure working with you to set up this program. And welcome all. This is the first one we've done this year, in this crazy year that we've had. It's the ICC Qatar's Commission on Arbitration and Alternative Dispute Resolution, shortened to ADR. As many of you know, ICC Qatar is Qatar's national committee to the International Chamber of Commerce based in Paris. And we work here in Qatar to connect the world to Qatari businesses. ICC Qatar has various commissions, many of which research, provide guidance and support in their various sectors and fields of experience. Here in the Arbitration and ADR Commission, we work to link arbitrators, counsel, users of ICC services, parties that is, to dispute, to help dispute resolution services respond effectively to your needs. As Mai mentioned, your audio and video have been silenced. You have not been. You can use the Q&A button, and we will see those questions. And at the end of our panel, we will endeavor to answer as many of those questions as possible. And finally, the slides that you see today will be made available after the program. So I will first introduce our goal today, and then our panelists, and then we'll get right into it. So there are many important emerging trends in international dispute resolution right now. And there are a wide number of topics to discuss. And then within each topic, there's a lot to discuss within each. But the goal of this program is to just get on your radar, to get on your screens, some of the more important issues that we're seeing here as we hit the end of 2020 and start to begin 2021. We'll reserve a deeper dive into these topics for later sessions, and we've been discussing on the sidelines planning for 2021. So we hope we're able to put together some deep programs for you, and we hope to see you on the other side of the year. Now, let me talk a little bit about the panelists we're going to hear from. Our first panelist, Sheikh Dr. Thani bin Ali bin Thani, actually cannot be here today live. That is unfortunate, but he was thoughtful and kind enough to record a video presentation in advance. He did that very quickly and powerfully. And the thoughtfulness and kindness does not end there, because Dr. Minas has, at the last second, agreed to join us and be available for the Q&A at the end of the program. Thank you, Dr. Minas. Dr. Minas, for those of you that don't know him, which is probably very few of you, is General Counsel at QICA. Now, Mai, before we roll the video, allow me to say a few words of introduction for each panelist. Of many important positions Sheikh Thani holds, of note for this particular program is that he is QICA's board member for international relations. And in 2018, he was appointed as Qatar's sole representative and member of the ICC's International Court of Arbitration. It's a very important role. Many of you know him. He's very active in the Qatar legal community. He presents at many local and international programs, and indeed tirelessly trains and educates all of us in the local legal community on all aspects of disputes, including arbitration. Now, we have a global panel today, all the way across the pond in Washington, D.C. We have Ian Laird. He's a partner at Crowell Moring. He's, like I said, based in Washington, D.C., along with Laurence Winston, who's also featured on the screen. They are co-chairs of the Crowell Moring International Dispute Resolution Group. Ian has over 20 years in international arbitration and has a primary focus. You'll hear a little bit from him about the disputes between foreign corporations and sovereign governments under international treaties, what we typically refer to as investor-state arbitrations. He's recently been involved in arbitrations in Egypt and Kuwait. He's an adjunct professor at Columbia University School of Law in New York City and at Georgetown University in Washington, D.C. We hope someday he will teach a class at Georgetown University in Qatar. In a previous life, he was chief of staff to a Canadian cabinet minister and a senior political aide to a Canadian minister of energy. And a fun fact about Ian, he has co-edited or co-authored 17 books. More than I can say. 17 more than I've done. Another panelist we have here is Ms. Randa Adra. She is based in New York City. Both of them we thank for getting up very early this morning over there on the East Coast. Randa has degrees from the American University in Beirut and Cornell Law School in New York, and has done postgraduate studies at a prestigious university in Paris. And I will not try to pronounce that in a nice French accent. Maybe we'll hear from Randa. She's got a beautiful Arabic and French accent. In her relatively short career of 8 years, she's managed to pack into her resume a slew of big-time international arbitrations and involving parties and seats of arbitrations in Egypt, Kuwait, Israel, Russia, and Hong Kong. She also finds time to represent pro bono or for free Middle Eastern clients in asylum and refugee resettlement proceedings. So just another example of me being the least qualified and least impressive person on this panel. Finally, we have Laurence Winston. He is based in London. As I mentioned earlier, along with Ian, he is co-chair of the Crowell Moring International Dispute Resolution Group. I can actually speak from personal experience that I've worked with Laurence in the past and in a previous firm, and it involved a case where we represented a well-known Qatari company. I say we, the royal we, because really he did most of the work and achieved all the good results. He is an expert in the type of relief that is very hard to obtain, but that can change the entire settlement environment. These are interim measures, things like freezing orders, search and seizure orders, posting of advanced security. In terms of sectors, he has a particular experience in complex banking and investment disputes, claims such as guarantees, indemnities, warranties, and he's pretty high profile. He recently acted in one of the highest profile cases in the world involving data and cybersecurity, and is the most polished of our presenters. No pressure, Laurence. He's appeared on CNBC Europe as an authority on commercial fraud. So before we get to Sheikh Thani's video, I do want to tell you a little bit about what he's going to discuss. So many of us are familiar with the New York Convention. It's used by over 150 signatory countries, including Qatar, to enforce international arbitration awards. Well, last year in August of 2019, the Singapore Convention on Mediation was signed by 46 countries as an international treaty. And in February of 2020, Qatar became the third country to ratify that convention, which triggered Article 14.1 of that convention. And that meant that the treaty just took effect 2 months ago on 12 September of 2020. We're now up to 53 signatory countries, and we expect this number to increase, especially because what we're seeing is the pandemic has really started to lessen some of the appetite for adversarial dispute resolution and look towards more some sort of conciliatory or mediated settlement. Now, by pre-recorded video, Sheikh Thani will discuss the importance of Qatar ratifying the Singapore Convention, and in particular, he'll discuss how it will significantly improve the range of legal options to Qatari companies involved in disputes. So, Mai, if you could...
Yes. I will share my screen now, and I will share the video with you.
بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام على أشرف المرسلين سيدنا محمد وعلى آله وصحبه أجمعين. بداية نتقدم بالشكر على القائمين على هذه الندوة، وسوف أتحدث عن اتفاقية الأمم المتحدة بشأن اتفاقية التسوية الدولية المنبثقة من الوساطة، اتفاقية سنغافورة. تعتبر الاتفاقية أداة لتيسير وترويج الوساطة باعتبارها طريقة بديلة وفعالة عن القضاء أو التحكيم لتسوية المنازعات التجارية ذات الطابع الدولي. ويعكس تبني الاتفاقية من قبل العديد من الدول، حيث قام على التوقيع على هذه الاتفاقية 53 دولة موقع حتى الآن وعي وإرادة المجتمع الدولي بأهمية وتعزيز وتفعيل الوساطة كإحدى الوسائل الودية الهامة لتسوية المنازعات، واطلاعها بدور مؤثر وحيوي في مجال تسوية المنازعات التجارية بصفة خاصة، وذلك من خلال سرعة التوصل إلى الحلول المناسبة التي يقبلها الأطراف، وفي الوقت نفسه تحافظ على العلاقة المستقبلية بينهم، كما توفر الكثير من الوقت والجهد والمصروفات. أهم الدول الموقعة على الاتفاقية تعتبر دولة قطر من أول الدول الموقعة، والمملكة العربية السعودية والأردن في الشرق الأوسط، كذلك الولايات المتحدة الأمريكية وكندا وسنغافورة والهند والصين وكوريا، وهذه من ضمن 53 دولة الموقعة على الاتفاقية. تصديق دولة قطر على اتفاقية سنغافورة، جاءت دولة قطر في الريادة بين الدول المنضمة لاتفاقية الأمم المتحدة بشأن اتفاقيات التسوية الدولية المنبثقة من الوساطة، والمعروفة باتفاقية سنغافورة للوساطة، من حيث التوقيع والتصديق، والتي دخلت حيز التنفيذ في 12 سبتمبر 2020 بعد أن صادقت عليها 3 دول، سنغافورة وقطر وفيجي، حيث أصدر حضرة صاحب السمو الشيخ تميم بن حمد آل ثاني أمير البلاد المفدى وثيقة التصديق على اتفاقية سنغافورة في 12 فبراير 2020 لتصبح الاتفاقية نافذة بعد مرور 6 أشهر. الهدف من إنشاء الاتفاقية: تضع اتفاقية سنغافورة إطاراً موحداً للاعتراف باتفاقيات التسوية بين الأطراف المتنازعة التي تتم عن طريق الوساطة ونفاذها على المستوى الدولي. تلقي الاتفاقية الضوء على الحالات التي يفشل فيها الأطراف في الالتزام باتفاق التسوية التي تم الاتفاق عليه وقت الوساطة، وبذلك أوجدت الاتفاقية سبيلا قانونيا يصبح قادرا على إنفاذ اتفاقية التسوية مثل حكم التحكيم. نطاق تطبيق الاتفاقية: تنطبق اتفاقية سنغافورة على اتفاقية التسوية المكتوبة أو المحررة كتابة بأي شكل من أشكال الكتابة، بما فيها الكتابة الإلكترونية التي تم إبرامها بين أطراف لجأت إلى الوساطة كوسيلة لحل خلافاتها التجارية. ويشترط في أن يقع مكان عمل أو نشاط أطراف اتفاق التسوية في دولة مختلفة، أو كان مكان عمل الطرفين مختلفاً عن الدولة التي يتم فيها تنفيذ جزء كبير من الالتزامات بموجب اتفاقية التسوية. تستثنى الاتفاقية من نطاقها الاتفاقيات الناشئة عن المعاملات التي يجريها أحد الأطراف المستهلك لأغراض شخصية أو عائلية أو منزلية، أو يتعلق موضوعها بقانون الأسرة أو الميراث أو العمل. كذلك تستثني الاتفاقية من نطاقها اتفاقية التسوية التي تتم أمام محكمة قضائية أو الناشئة عن قرارات تحكيمية. نجاح الوساطة ومعدلات إنفاذ اتفاقيات التسوية: يقصد بتعبير الوساطة عملية بصرف النظر عن المسمى المستخدم لها أو الأساس الذي تجري بناء عليه، تسعى من خلالها الأطراف إلى التوصل إلى تسوية ودية للمنازعة القائمة بينها بمساعدة من شخص آخر واحد أو أكثر يسمى الوسيط، ليست له صلاحية فرض حل على أطراف المنازعة. من الملاحظ أن المعدل الفعلي للامتثال وإنفاذ اتفاقيات التسوية التي تم التوصل إليها عن طريق الوساطة مرتفع جدا، حيث أنه من غير المرجح أن ترفض الأطراف إنفاذ الاتفاق التي شاركت في التفاوض عليه ووافقت على ما جاء في بنوده. الإطار التنظيمي للوساطة في دولة قطر: أحكام خاصة بعقد الصلح في القانون المدني. لا يوجد قانون خاص بالوساطة في التشريع القطري. توجد قواعد خاصة بالتوفيق والوساطة لدى غرفة تجارة وصناعة قطر ومركز قطر للمال، وكذلك قانون غرفة تجارة وصناعة قطر المادة 4 فقرة 9 اختصاصات غرفة التجارة، وهي أحد اختصاصاتها الوساطة. توجد قواعد خاصة بالتوفيق لدى مركز قطر للدولي للتوفيق والتحكيم، استلهمت من القواعد النموذجية للتوفيق التي أصدرتها الأونسترال. توجد قواعد خاصة بالوساطة لدى محكمة قطر الدولية لمركز قطر للمال. توجد قواعد خاصة بالوساطة في أغلب مراكز التحكيم والوساطة الدولية ICC ICIA والأكسيد. أسباب رفض إنفاذ اتفاقية التسوية الدولية. على غرار النهج المتبع في اتفاقية نيويورك، تشمل الاتفاقية على قائمة حصرية بالأسباب التي تجيز للمحكمة المختصة أن ترفض إنفاذ اتفاقية التسوية، وهي عدم أهلية أطراف اتفاق التسوية أو كلاهما، أن اتفاق التسوية المزمع تنفيذه باطل أو لاغ أو غير ساري المفعول، أن اتفاق التسوية المزمع تنفيذه غير نهائي أو غير ملزم لأطرافه أو أنه عدل لاحقا، أن الالتزام الوارد في اتفاقية التسوية قد نفذت فعلا أو أنها غير واضحة أو غير مفهومة، أن قبول إنفاذ اتفاق التسوية سيكون مخالفا لشروط ذات الاتفاق، إخلال الوسيط بالمعايير التي تم الاتفاق عليها في الوساطة بشأن الوسيط أو بشأن عملية الوساطة، عدم إفصاح الوسيط عن الظروف والملابسات المثيرة للشكوك بشأن حياديته واستقلاله نتج عنه تأثير جوهري على أحد الأطراف. كذلك تشمل الاتفاقية على قائمة بالأسباب التي تجيز للمحكمة من تلقاء نفسها أن ترفض إنفاذ اتفاقية التسوية، وهي أن موضوع المنازعة غير قابل للتسوية بطريق الوساطة، أن تنفيذ اتفاق التسوية سيكون مخالفا للنظام العام في الدولة. شكرا لحسن استماعكم وشكرا للجميع.
Thank you, Mike, the sound did come on halfway through, but the subtitles thankfully were there for all the English speakers. And we certainly thank Sheikh Thani very much for putting that together in advance to solve the problem of his unavailability today. So very good. So we look forward to hearing more about that, hopefully live next year from Sheikh Thani himself. So our next presenter will go right to Mr. Ian Laird. So Ian, you may have been able to follow along in the subtitles that Qatar's made a big commitment to mediation now and is looking to be one of the leaders in this area. So I think it's important for the attendees, most of whom I think are here in Qatar, to know that the ICC has a set of mediation rules. Many people might not know this. They have ICC is famous for its arbitration rules, but they have a set of mediation rules that can serve as a companion to the Singapore Convention. And I think in particular, the audience would like to hear how does mediation work internationally, and how parties in Qatar can use the ICC mediation rules to help obtain a contractual settlement with confidence that it'll be enforced in foreign countries.
Well, thanks very much, Tarek. Are we going to put up the slides? Okay, we have some slides to assist you. While that's going on, I just wanted to thank the organizers at the QCCI and at the ICC Qatar. This is a fantastic event and a very timely one. So I'm very pleased to be here and to be able to talk to you today. And following Sheikh Thani, that's a bit of a tough job, but I'll do my best. I really do echo his sentiments. I think the signing of the Singapore Mediation Convention, and it's by Qatar and its ultimate ratification, and then coming into force this past September, is a very important event in the international dispute resolution field. The United Nations Center for International Trade Law, the UNCITRAL, has been looking at this issue for many years, and it's been a long time in coming because, as was explained by the Sheikh, and Tarek earlier, we have the New York Convention, which is a similar UNCITRAL convention signed by over 150 countries, which allows for the enforcement of arbitral awards. And this has always been one of the great strengths of international commercial arbitration, is that you can have diverse international parties engaged in a contract. They put international arbitration into their contract as a dispute resolution provision. And then that allows the parties to enforce the ultimate award from the arbitration in a court anywhere in the world, or at least anywhere in the courts of the signatories to the New York Convention. And it really is a very powerful tool for international business, that they can resolve their disputes and then have them enforced in such a manner. And the other option, of course, is always litigation. But there's a little more difficulty sometimes in getting enforced across borders. But with arbitration, you have a very direct mechanism. And this is what the UNCITRAL has built upon, taking that model, the idea that the parties can control their dispute resolution process, whether it's through arbitration, and then now mediation, which again focuses on the idea that a parties to a dispute, commercial parties, would like to keep control of their dispute, not go to courts, and ultimately try to reach a settlement. And one of the I wouldn't say faults, but sort of one of the things that needed to be improved on in the New York Convention was to allow the parties to go off to seek a mediated settlement rather than an adversarial resolution, which is what arbitration ultimately is, to get together and at its very simplest, to appoint a neutral individual who has great experience as a mediator in the process of working with parties, trying to address their interests, whether they're not just business or legal or other interests that can resolve in a amicable resolution. And this is Sheikh Thani was referred to, the key part of the Singapore Convention is the parties would come to a settlement agreement, and that this agreement then much like an award, say, or final or binding award in an arbitration, but this settlement agreement then could be brought before whatever courts are necessary to enforce those terms. And having the ability to enforce in courts, of course, gives the parties a lot more leeway and ability to make the agreement work. So if we can just go through the slides, the first slide summarized some of the information that was being given earlier by the Sheikh. The convention, of course, has 53 signatories in Qatar. And I just wanted to mention Qatar was the third signatory, which actually put the agreement into force. And it really is a great signal to the international community of Qatar's commitment to growing international dispute resolution and mediation. If we can go to the next slide. The one comment, and I don't want to be too negative, because I do think that the take-up and the participation in the convention will end up likely being very similar to the New York Convention on arbitration. And partly there may be an explanation due to the events of the past 9 months. Might have been distracting to some, and the priority of ratifying the Singapore Convention might have been low on some states' lists. But one interesting observation is that the EU states in Europe and a lot of developing countries, we'll call them, have not signed on to the convention yet. And that may have to do partly with the fact that the EU and even the UK, which have their own systems of mediation, and that is a preference for them. But I think we can anticipate in the future that we'll see a greater sign-on. Tarek mentioned earlier my background doing international investment disputes, and these are disputes that involve sovereigns, usually as respondents, and the claimants being international investors, usually involved in large projects, infrastructure, and the like. And one of the issues in international investment arbitration has always been this question of whether mediation should be used more, why it's not used more, and those kinds of questions. And I think part of the hope of the Singapore Mediation Convention is that it will go just beyond, mere, simple commercial interactions, and that it may allow for a better resolution of all international disputes. The one caveat that seems to be being placed in the reservation portions of the convention, and each state is allowed to reserve and to limit the application of the convention. And we've seen in the case of KSA and Belarus that they've limited the application so that it doesn't apply to states if a state is a party, or one of its agencies, or even, using this broader wording, anyone acting on behalf of the state party. So that's a little disappointing, as I said, one of the hopes is that the convention would apply more broadly to disputes involving sovereigns. But that doesn't mean mediation still can't work with those sovereigns. It just wouldn't apply and be enforceable under the convention. Just a little note here, we've got a very nice news alert on this if people want to read more deeply. If I can go to the next slide. So I just provided the definition here. Actually, Sheikh Thani basically read this out just to give you a sense. If you're not familiar with mediation and want to understand it more, it really is a very, the benefits are many. One of the key benefits is the autonomy of the parties to work together and to resolve their dispute in a less adversarial manner than, say, going to court or arbitration. And that's considered one of the very strong elements of it. I put as the key benefit of mediation, and the ICC has mediation rules, and they're very well developed, is that you get access to ICC arbitrators and mediators, and that the ICC will assist administrating the process. So it's a very comprehensive service, and it really is something that makes the ICC stand out above other service providers. And if we can go to the next slide, and I think I'll finish off here with these last couple of points. I also want to mention that it really fits well with the New York Convention. The lower costs of mediation compared to going to court or arbitration are clear. And my final point there is, of course, the confidentiality, and the flexible process is a key part of this. So mediation has so many upsides that it really is something that parties should look at very clearly when they're dealing with disputes. One last slide, and I think I covered this, is the less adversarial part of it. So Tarek, I think it was great getting Sheikh Thani to talk about this and to raise the profile of the Singapore Convention. It really is a fantastic new development, and the fact that Qatar is embracing the new convention, and I have to echo what you said earlier, that it really will increase the legal options for Qatari business community, and should look very seriously when settling disputes at mediation.
Well, thank you, Ian, and thank you for that for that perspective from the U.S. side of things. Coming from being educated and trained in the U.S. myself, mediation is a very, very large part of dispute resolution in the U.S. and has been for a long time. Indeed, many courts require mediation before you pass certain steps in the litigation process. So We appreciate you weighing in on that from your perspective, from a country that has a very sophisticated mediation regime. Let's move on to the next new development that we'd like to discuss today, which is actually moving back to the adversarial process. That's arbitration. So the ICC has recently passed a set of amendments to their arbitration rules. The current rules, effective March of 2017. And so here we are about 4 years later, and their amendments have been passed, and they will be taking effect on 1 January 2021. Now, Randa, we all know the ICC is famous for complex, high-value, multi-party, multi-contract disputes and arbitrations. Please discuss the new amendments and kind of some of the highlights of what we should expect to see in 2020 and beyond.
Thanks, Todd. Sure, I'd be happy to. And good afternoon, everyone. Thank you so much for having us today. And I'm very excited to be with you all to discuss these important updates. I'll ask that the slides be put back up and we can move on to the next slide. Perfect. So as Todd mentioned, these 2021 ICC arbitration rules were announced last month, and they'll be finalized next month and then enter into force in January 2021. And a couple of things to note on that point. Only arbitration matters submitted to the ICC court after the 1st of January 2021 would be subject to these new rules, not ongoing arbitration matters. And in conjunction with the new rules, the ICC will also release an updated note to parties and arbitral tribunals on the conduct of arbitration, which should also provide some helpful guidance as well for practitioners. So overall, the updated rules are not a significant departure from the 2017 rules, but they do impact 3 key features that will make ICC arbitration even more appealing to parties. The first is flexibility, and the changes are mainly in the form of a shift towards allowing virtual hearings and electronic submissions. The next is transparency, particularly in avoiding conflicts of interest. And third is efficiency, which is especially important in the case of complex disputes, where the joinder of additional parties and consolidation can aid in the more efficient resolution of a dispute. And we'll discuss how the revised rules impact each of these features in turn. Before I do jump in, though, I do want to note that we won't be discussing all of the changes in the rules today, only a few of the more significant changes that we think will be of interest to this group. And we can go to the next slide. Thank you. And we'll begin by discussing the rules that support greater flexibility, starting with Article 26. And this article deals with hearings. And as you can see on the slides, the original 2017 language provides that, quote, the parties are to appear before the tribunal for a hearing. And while much of the original language from 2017 has been preserved in the new rules, new language has been added, allowing tribunals to, quote, decide that a hearing will be conducted by physical attendance or remotely by video conference, telephone, or other appropriate means of communication. It's fairly clear, and we can all imagine, that this revised language is at least partly in response to the new realities that we're all facing right now with the global pandemic. But nonetheless, the broad language in this revised provision provides the flexibility that both the tribunal and the parties would need to decide the best way to proceed with their hearing. The impact will last far beyond the pandemic, and it could reach numerous situations where virtual hearings simply make more sense for everyone involved. And it bears noting that the language at the end of the new provision, other appropriate means of communication, it also takes into account that new technology might become available in the coming years. And it's likely an effort by the ICC to avoid needing to rewrite this rule again in the near future because it limited parties only to technologies currently available. So that broad language, I think, will be very useful. We can go to the next slide, where we'll discuss Article 3, which deals with notifications and communications, which has similarly been amended to allow parties more flexibility in how documents and communications are shared and exchanged. As you can see in red, parties are no longer required to submit paper copies, but merely to, quote, send materials. So this eliminates the requirement for physical copies, which can be quite burdensome, quite substantial. And again, this not only accounts for changes that result from the pandemic right now, but it also brings the rules up to date with the reality that parties in tribunals are already agreeing to exchange pleadings and communications electronically, and they've been doing so for some time now. It's more efficient, it's more cost effective for everyone involved often. And so the revision to this rule really acknowledges this reality and allows parties to proceed with electronic exchanges without the need of an additional agreement to do so. On the next slide, we'll move to changes that afford greater transparency. The first is Article 11, which deals with general provisions related to the arbitral tribunal. And this new subsection, in essence, requires disclosure of third-party funders, specifically, quote, of the existence and identity of any non-party which has entered into an arrangement for the funding of claims or defenses, and under which it has an economic interest in the outcome of the arbitration. This really brings the provision up to date with the IBA guidelines on conflicts of interest in international arbitration, which required such disclosure. And it's really particularly appropriate in light of the growing use of third-party funding in international disputes. And the greater transparency aspect is in the fact that now parties are required to disclose such third-party funders. And on the next slide, you see that Article 17 has also been substantially reworked. This provision previously dealt with, quote, proof of authority, but it's now called party representation. Much of the 2017 language has actually been incorporated into the 2021 provision, but there's an entirely new subsection 2 in the 2021 rules, and it allows the tribunal to, quote, take any measure necessary to avoid a conflict of interest of an arbitrator arising from a change in party representation, including the exclusion of new party representatives. Now, this is certainly a step towards transparency and minimizing the risk of conflicts of interest in an arbitration. But it does bear noting that it might result in some tension between both this desire for transparency and avoiding conflicts of interest and the desire for party autonomy and the right to choose one's counsel. So it'll be really interesting to see how this plays out in practice and how often this provision is actually invoked. On the next slide, we move on to the ways that the new rules increase efficiency. And we'll discuss some of the changes that are particularly impactful on complex arbitrations, where there are numerous parties and related agreements involved. And many of you who work in construction arbitration might find this particularly of interest. Article 7, which you see here, deals with the joinder of additional parties. And subsection 5 is a brand new section. For some background, the 2017 rules did not allow for the joinder of an additional party after the appointment of any arbitrator, unless all parties were in agreement. This language has been completely removed from the 2021 rules, and under this new subsection 5, the tribunal may allow for the joinder of a party after the confirmation or appointment of an arbitrator, provided that the additional party accepts the constitution of the tribunal and after the consideration of various factors, such as the potential impact of the joinder on the arbitration as a whole. So by removing the requirement that all parties consent to the joinder of an additional party, it really increases the likelihood that parties can more easily be added to a dispute if the arbitrator sees it fit and after considering all relevant factors. And it allows complex disputes to be resolved more efficiently. And finally, on the next slide, we'll discuss Article 10. And there's been a very slight revision to Article 10 related to the consolidation of arbitrations, but it's more significant than it might seem at first blush. Article 10b has been amended to allow for consolidation where, quote, all of the claims in the arbitration are made under the same agreement or agreements. And why is this addition of, quote, or agreements significant? Well, this will now allow for the consolidation of cases between different parties that arise out of more than one arbitration agreement, as long as all the parties are subject to the same arbitration agreement. This makes ICC arbitration a lot more appealing for complex and multi-party arbitrations, especially where there are a number of parties all subject to multiple arbitration agreements. The end result will likely be the more efficient resolution of disputes that arise out of such complex relationships and deals. So as you can see, the changes to the rules are not particularly dramatic, but they are significant and could be useful tools to consider as you engage in future arbitrations moving forward in 2021.
Thank you, Randa. There are many amendments. One that caught my eye, based on a personal experience I had this year, was the change in the expedited procedure rule. It's a small change, but I think it's noteworthy. The expedited procedure provisions of the ICC rules took effect in March of 2017 and have proven to be quite successful, actually. The current rule says that if you choose ICC as your arbitral institution, if you choose in your agreement to have an ICC arbitration, and your dispute is under $2 million in dispute, you are presumed to fall under the expedited procedure rules, which calls for awards to be issued in 6 months and a whole host of other very efficient procedures. I actually served as a sole arbitrator in an expedited procedure case this year during COVID. We went start to finish and issued the award, and it worked very, very well, actually. The parties were excellent, very cooperative. I think everybody bought into it. The new rules will increase the threshold to $3 million. So if you choose ICC as an arbitration in your contracts after, as you pointed out, after January 1, for contracts entered into after January 1, then the threshold goes up to $3 million, which will capture more arbitrations, and more arbitrations will be presumed to be under the expedited procedures unless you opt out. So something to watch for as we go down. Thank you, Randa. Very, very lot to pack in there. We'll see how this all goes. But it is very important to know that the changes don't mean that anything happening right now is all of a sudden going to change in midstream. These are for new. Thank you. By the way, I love the way Randa says my name. That's how my father's from Egypt, and she's the same way. I just absolutely love that. Thank you for that. All right, so moving on to our final topic before the Q&A. Let's turn to interim measures. This is becoming an increasingly hotter and hotter topic because before the pandemic, it was becoming quite a topic. Now, during the pandemic, companies are having even more difficulty with cash flow, liquidity, and creditors pursuing relief are increasingly requesting our advice and counsel and seeking from courts and from tribunals and emergency arbitrators, ICC emergency arbitrators, interim measures. So turning to Laurence. Now, earlier I mentioned that I know you've been involved in helping a very important Qatari company obtain a freezing order up in London on an international arbitration award. And I think our attendees would love to hear a little bit more about that experience. And then also how enforcement of a final award, well, actually put a different way, how enforcement of interim measures has a unique set of challenges compared to enforcing a final award.
Thank you very much, Tarek. And I must say, I can't really compete with Randa as to how I say your name, but anyway, let's move swiftly on from that.
I like the way you say it too.
Good afternoon to everyone from a somewhat cold and damp day in post-lockdown London. So I'm delighted and honoured to have the opportunity to talk to you today about interim measures in ICC arbitrations, and also to touch on the effectiveness of arbitration when it comes to enforcement of awards. So let's look at interim measures in international arbitration. So interim measures are intended to address the needs of parties who require urgent assistance prior to the final determination of their case. And the solution to the need for urgent assistance is for arbitral tribunals or the courts to grant interim relief. They're set out in the ICC rules in Article 28, which deal with conservatory and interim measures, and 29, dealing with the appointment of an emergency arbitrator. And as Randa helpfully covered the changes between the 2017 and the 2021 rules, they remain unchanged insofar as they relate to interim measures. So let's look at the types of orders they cover. They cover a very wide range of orders, but the types of orders are not listed in the rules. They're not dealt with prescriptively. Instead, the tribunal has powers to order any interim or conservatory measure it deems appropriate, subject to appropriate security for cost being put up by the requesting party. So the tribunal has very significant discretion in relation to interim measures. They are usually granted at an early stage in the proceedings, and orders usually relate to such things as preserving the status quo, the prevention of the dissipation of assets or evidence, usually known as conservatory measures, which should ordinarily be made without delay. So, taking, for instance, a construction project, interim measures might include ordering a party to continue performing its obligations pending resolution of the dispute to ensure there are no delays to the completion of the project. So, for example, a contractor may want interim payment applications to be processed without delay to provide cash flow during a project, or an employer may wish to prevent suspension of works so as not to cause delays to completion. They may also relate to preserving documents or evidence, or to freeze assets if there is a risk of dissipation which might render the award worthless. And I'll come on to some of the enforcement issues in a moment. One procedural difficulty is that the tribunal obviously needs to have been constituted in order to make such orders. So what happens when there is a need to obtain interim remedies in advance of the arbitral tribunal being constituted? Well, this gap is filled by the emergency arbitrator procedure, where parties can apply for the appointment of an emergency arbitrator under Article 29 of the rules. Applications should be made to the president of the ICC court, and looking at some of these statistics, it is fairly rare for an appointment to be declined. So, leaving aside any challenges that may be made to the appointment of an emergency arbitrator, the emergency arbitrator has wide powers to order urgent interim relief, and very helpfully, a reasoned order must be provided within 15 days. But the parties, and I would always urge this when considering where to seek interim relief, especially emergency relief, is parties should consider carefully whether to seek interim relief in the local court or from the tribunal. And I now want to just move on and have a look at some of the issues that there are in relation to enforcement. But if we could move to the next slide, please. So let's look at some issues to consider about interim measures. So the tribunal has no coercive power to compel compliance with an interim measure. And so whilst parties under the rules might have agreed to comply with any order of the tribunal, the rules are silent on the remedy. And you can't generally enforce an interim measure against third parties, as of course, they are not parties to the arbitration agreement. And for example, if one looks at a case where a freezing order may be appropriate to prevent dissipation of assets, if it needs to bite against a third party, then an interim measure from a tribunal may not be appropriate. There are also difficulties often encountered in trying to enforce, particularly emergency arbitration orders. So under the New York Convention, which we've mentioned, and I know Ian mentioned earlier, there are frequently significant difficulties to enforcement, as they're often issued as orders as opposed to awards, and may well be viewed as lacking the finality requirement so as to be enforceable under the convention. There is then the further issue, and particularly in the case of freezing orders and asset preservation orders, or search and seizure type orders, and something I've done an awful lot on, is whether one goes on notice or without notice. So a tribunal is likely to be very reluctant to grant without notice orders, as this cuts right across the two fundamental tenets of legal process, being notification of the application and the right to be heard. Now, if one envisages a freezing order, this could be very problematic, as if one goes on notice, you're in effect saying to the other side, we're coming after you. But of course, the time between that and the hearing puts them on notice to dissipate should they so choose. So again, that's a significant issue that parties need to consider. In addition, there may be a reluctance to grant interim measures if they're seen as prejudging issues in arbitration. And frequently, the tribunal will often require security for costs in relation to interim measures. There is also a cost to appointing an emergency arbitrator of $40,000 under both the 17 and 21 rules. And if parties are considering which route to go down, what I would say as a general summary is if there is no urgency or third parties involved, and the tribunal has the power to grant an interim measure, go to the tribunal as it will hear the substantive dispute. Otherwise, if a party requires urgent measures, say to preserve assets or evidence, or if there are third parties involved, consider whether a local court may be appropriate. If we could move to the next slide, please. So before closing, I just wanted to pivot from enforcement of interim remedies to enforcement of final awards, which of course, and as we discussed earlier in this presentation, is one of the great advantages of arbitration over court proceedings. So awards are enforceable in most countries across the world under the New York Convention, and over 156 countries are signatories to the convention. And the convention enables parties to have a very straightforward route to have recognized and enforced by an application of the local court where a party is seeking to enforce. So this means that you can easily take your award and seek enforcement, usually with little difficulty, in the jurisdiction of where the assets are located. And of course, there are challenges, but these are very limited, and the success rate for a challenge to a final award is very low. And as Tarek mentioned earlier, I just wanted to provide a really good example of the effectiveness of enforcement in international arbitration from a recent case that we handled together. So we acted for a major Qatar entity who was the unfortunate victim of a $300 million fraud. A final arbitration award was obtained in India. The defendant was under an arrest warrant, but he absconded to London and he was subject to a red corner notice. There were significant assets in London, and we were able to obtain at very short notice before the High Court in London an urgent without notice worldwide freezing injunction and a passport confiscation order, and then take enforcement steps in the UK as though it were an English judgment, all of which obtained the relief for the client that they desired extremely quickly, and a very effective and efficient route to getting the judgment, the award enforceable and enforcing against assets where they're located. And this is a major, major consideration when it comes to parties considering whether to go down the route in contractual agreements of whether the court route or arbitration. And arbitration has huge advantages when it comes to enforcement, because court proceedings where there is no recognition or treaty between countries are significantly more difficult to enforce. So to sum up, when it comes to the developments, the jurisprudence of interim remedies, appointment of the emergency arbitrators and the enforcement of interim remedies is a developing area, and we expect to see continuing changes over the coming years. Obviously, for the enforcement of final awards, this is much more settled, and generally speaking, awards are easily enforceable in most countries across the world, thereby making arbitration a very attractive means of resolving disputes over court proceedings. I must apologize that this has been a bit of a whirlwind tour, but I hope you found this presentation helpful, and thank you very much for your time today. And with that, let me pass it back to Tarek.
Laurence, thank you for going through that. I know, from experience, and I think others probably attending also know that these, when seeking interim measures, this is one of those, very fast-paced, time-sensitive, lots of issues, lots of sensitivities to consider. It's actually one of the areas when we're called upon and instructed to do that type of relief. It actually, is one of those areas that a lawyer, can really get excited about. So. We have, turning to the Q&A, I know we're running a little bit late, but hey, it's Thursday afternoon here in Qatar. We have very few Q&A from the attendees, which means one of two things. Either you did a fabulous job or everybody left. So let's talk about one question I had in mind, which is we've covered mediation and some arbitration, and we've talked about the new ICC rules and virtual hearings. And of course, here we are in 2020. So maybe I'll just ask the most obvious question. Anybody on the panel been involved in a virtual hearing, either in an arbitration or a court or a virtual mediation? I don't know if that's taken hold yet.
So Tarek, I'm happy to take that because I did a virtual court hearing in London in the High Court earlier this week, actually. And in truth, the virtual hearing worked extremely well, save for one thing. The opposing counsel couldn't get his internet to work, so he kept cutting out just at the time he was making submissions, and he must have cut out 5 times, with the effect that he had to then redial back in on the phone, and the judge insisted, for equality of arms, that the videos be turned off because, of course, the opposing counsel then couldn't see anyone. Save for that, it worked well.
Well, there are going to be a lot of fun stories, I think, coming out of this environment. We're going to have to make fun of it somehow. Ian or Randa, any experiences you want to share?
Thanks, Tarek. Yeah, actually, I was also in a virtual hearing early this week, and we had folks in Hong Kong, the west coast of the U.S., Washington, London, Paris. It was one of those truly international arbitrations. I think the real difficulty was just getting everyone's timing lined up. So we ended up having to start at 6 a.m. Washington time, which I think was like 7 p.m. in Hong Kong. And so we were up early, they were up late, but it went very smoothly. I think the key thing is to get the technology all in line earlier, have enough organizational sessions with all the participants in advance that they can get their equipment all set up and make sure that the Wi-Fi works and just all that technical stuff. Frankly, at the end of the day, it's about practice and getting used to the process. I think it can work well. Doesn't have, I think, what many of us, we like to be in the room with the witnesses and the arbitrators, and to have that, basically it's a human process. It's a decision making. It's about the assessment of character and credibility and all of those things. But I think in the circumstances, the one benefit out of the COVID thing is that it's forced us all to take the virtual world very seriously, and I see us advancing very quickly. And in fact, I've got 3 more hearings over the next 2 months that are going to be virtual. So ask me in March, and Randa's going to be in one of them with me, and we'll have a lot more to say, I'm sure.
Randa, do you want to offer any experiences you've had this year?
Well, I mean, my first hearing is going to be in February, so that'll be an interesting experience. But even just trying to prepare submissions with witnesses that you can't be in the room with, and witness statements, and all of these very complicated documents and fact collection, where normally we're in the room, we can't be. It's really hard to maintain people's attention and to have these really long conference calls over video. But everybody seems to be doing their best, and everybody's doing their best to make it work. And I think it's doable. It's definitely doable if everybody puts in a little extra time to get used to it. So I think people shouldn't be concerned about it, but just be prepared for it.
We have another question that just came in, and it's one that we've been grappling with here even this week. And that is, the decision whether to agree to a virtual hearing, in a matter of substance, seems to be, and I think this is pretty natural, to be dependent on the amount of controversy, right? So I mean, if you're talking about a relatively small case to your company or whatever, maybe you're more agreeable to a virtual hearing, and maybe you're not as concerned about the safeguards, and maybe the video cuts out, and maybe you're a little more tolerant of those issues. But I think the tougher thing will be for the high value stakes cases. I think it's going to be hard to convince parties to agree to a virtual hearing. And then, of course, you have a problem where one side may consider the dispute to be fairly small and thinks a virtual hearing is no problem, and the other side considers it to be a bet the company case and insists on the physical hearing. So, I think we're going to see tough decisions that need to be made by arbitrators, and maybe that all leads all the way back to maybe everybody should do a virtual mediation and see if we can get it resolved that way. I've actually been hearing stories from colleagues and in my network that people, that parties are starting to mediate more because of the challenges of virtual hearings. And instead of having a virtual hearing on an important substantive matter that might be fraught with due process considerations or the lack of trust, that they've worked it out in advance. They've worked out the issue in advance because of the challenges. So anyway.
And I'd add on to that one extra point. We got a question about whether or not we think virtual arbitrations will become a norm. I think that there's something to be said about the human element that Ian referenced earlier, and about maintaining people's attention and having good and strong interactions with people when you're all in the same room. I find it hard to believe that once this strange period we're all experiencing is over, that people will be comfortable moving to virtual arbitrations permanently. There's a lot of benefits to being in the same room with the witnesses and with the arbitrators, and the showmanship of an arbitration can also have a real impact on the outcome. And you can't capture all of that as well when you're on a computer screen. But that being said, we've seen in some of our bigger, high stakes arbitrations worth over $1 billion that sometimes a witness needs to testify virtually. And before, that was a real problem because you had to overcome strict interpretations of the ICC rules where they say that, if you want to cross-examine a witness, they need to be in the room. So now having the opportunity and the leeway for more virtual hearings and testimony will actually help parties who find that there's an actual need to not bring a witness in, whether it's because of health concerns or if you're dealing with a sovereign on the other side and they're concerned about traveling to that country. There's a lot of considerations that now I think the breadth of the new rules will afford parties to take into account and to make more educated and informed decisions about whether or not virtual makes sense versus physical attendance.
Very, very good point. I mean, don't rule out the hybrid, right? I mean,
right.
It doesn't, because you're going to have a virtual arbitration doesn't mean a hearing. It doesn't mean the entire thing has to be virtual. Maybe you have a chunk of it that makes some sense, but the rest of it's in person. So yeah. Let me just check the Q&A one more time. Okay, I think we're good. I think we've answered. Well, I thank everybody for attending, and I thank the panelists and Sheikh Thani. If anybody wants the slides, I think you have, or you might be distributing those just in general. But unless anybody else has anything to offer, I think my role is done. Maya, I think you're on mute. We can't hear you. Okay.
Yes.
I would like to thank you all for this wonderful webinar.